Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients and their families. Our law firm is committed to providing the highest level of professional service through aggressive advocacy and serving as a trusted advisor during a tough situation. To learn more about our law firm, read my weekly blog, watch my videos, or download one of my strategy books, visit gambonelaw.com or call 215-755-9000 24 hours a day to schedule an appointment. This podcast is for information purposes only and does not establish an attorney-client relationship. Well, welcome to podcast 10 of the Gambone Law Podcast. I can't believe that this is our 10th podcast. So far, we've received some great responses from our clients and our families, and so we're going to keep doing this. Every week, I'll be discussing issues in the area of criminal defense with a focus on your constitutional rights. It is my hope, as always, that these questions and answers will provide someone out there with some assistance. If you have more questions, obviously, after listening to the podcast, you can always call our law firm at 215-755-9000 or visit the website, gambonelaw.com. On the site, you're going to find the previous podcast. You're also going to find a lot of other information, links to videos, books, a lot of downloadable information, so I encourage you to do that. Finally, before I get started, if you enjoyed these videos, please like and subscribe. It really helps us get our message out there. So, this week, I want to discuss the safe injection sites in Philadelphia. And what I want to do is kind of explain, there was rumors out there that had the site been built in South Philadelphia, or not built, but rather put in South Philadelphia, either state or local, state or federal authorities could have stepped in and attempted to kind of put them out of business through just standard police tactics. Now, it's my understanding, allegedly, had the sites been put in place, the Philadelphia police were not going to stop individuals leaving the site and search them for illegal narcotics. But federal and state authorities, there was an issue there as to whether or not they would get involved. Because obviously, outside of some local leaders, there were the average person in Philadelphia, especially South Philadelphia, was not in favor of this. People came out in droves to protest it, and ultimately the site was not put there. Now, it's my understanding that the issue is not over. Like anything else, I'm sure there'll be possible litigation, and I'm sure that they'll be addressing these sites again. So what I'll be discussing today is, how police at the state and federal level could have done this. You have to understand that obviously there's local police, the Philadelphia police, for instance, but there's also obviously state troopers who have an investigation division, and obviously the federal government through various law enforcement agencies like the FBI, the DEA, can also exert police power and make stops and even arrest if necessary. So I want to discuss the issue of stop and frisk, and what we'll do is we'll go to our questions and we'll go from there. So the first question I have here, a client I've asked in the past, is what allows police to stop a car or a person on the street? Well, these are two different situations. So first, I want to deal with the stop of a car. When police want to stop a car, they have to have probable cause to believe that the car has done something wrong, and well, obviously the driver. So, and when I say a probable cause, people may think that there must be some type of, just gross crime of some sort, but really it just has to be just a standard traffic violation, like running a stop sign or speeding. That in and of itself will give police probable cause to make a stop. Now, after that stop is over, then we get into issues like probable cause to search, reasonable suspicion, and things of that nature. Now, with regards to a traffic stop or a vehicle stop, if police have probable cause, following that, they can stop the vehicle and begin having a conversation with the driver. Based on that conversation, if they believe that the car contains contraband, they can at that point do an investigation and they can search the car for that contraband. During the course of that search, they can also pull the driver and the passengers out and do a frisk of the driver and the passengers for their own safety, or potentially if they believe the passenger or the driver have contraband on them based on the sight or the smell of something, or something based on their experience and training to believe that this individual is possibly armed or has contraband. And what they can do is, during the course of that search, that pat-down search, if they find something that they believe is contraband, they can seize it if, through that manipulation, they can determine that this feels like a gun, or this feels like drugs, or this feels like some type of contraband based on their experience and training. So that is the vehicle stop. Very frequently, we encounter these issues in things like drunk driving, drug cases, gun cases, just a gamut of cases that we handle at our law firm in Pennsylvania and in New Jersey. Now, the second part of that question is, when can police stop a person on the street? You have to understand that a pedestrian stop is different than a vehicle stop. Police, if they want to, they can simply go up to an individual and say, well, may I speak with you? Now, this is an example of what the law calls a mere encounter. There is no obligation on the individual stop to speak with police. So using the example of the site injection center that was going to go in South Philadelphia, if police wanted to make a stop and simply ask the person who had gone to this center and come out, hey, may I speak with you? There's no obligation for that person to comply. They can simply say, no, officer, I'm not going to speak with you. Now, in the safe injection example, however, what was proposed or what people thought police could do, and they could stop an individual under the belief that the person had contraband on them because they had just visited a site where they allegedly had injected some type of illegal substance. So that would have given police reasonable suspicion to at least do a pat-down search. Now, in that situation, you have to understand that that's not probable cause to search. It's just suspicion, reasonable suspicion to perform a stop and a frisk. At that point, the person's not under arrest, but the officer has detained them in order to do an investigation. The person's not obligated to speak with police, but at the same time, the officer is permitted to do a pat-down search. If that search reveals nothing, at that point, that person is free to go. If the officer continues the investigation, he or she must have an independent basis for the continuation of that investigation. Without that, then that detention becomes illegal. With regards to probable cause to search, using the example again, if the officer has manipulated something and he finds that this item feels like it's drugs or contraband, at that point they can seize it. And at that point, if it is contraband, using the same safe injection example, the officer can seize it and place the person under the arrest. The issue is whether or not that actually would have happened, whether or not state or federal authorities would have gotten involved. It's my understanding that Philadelphia police were being directed not to make those stops, but that's one way that they could have seriously discouraged that site from opening up, because really, what user would go to a site knowing that more than likely, or there's a good possibility that they would be stopped and possibly arrested by the state or local, state or federal authorities. But obviously, we're talking about possibly small cases, so there's an issue as to whether or not those authorities would even get involved. But there is a constitutional basis for all of that. So it's an issue that may become more important as the issue of safe injection sites becomes more discussed in the news and possibly in Philadelphia. Okay, let's take our next question. Okay, why is speaking to police a bad idea? Well, again, I always advise clients never to speak to police, and the reason why I say that is because it's never going to help your case, and if anything, it's going to prolong a possible investigation. So, using the example of being stopped on the street, if the officer says, "Hey, I want to speak to you," you don't have to be a jerk, you don't have to be impolite, but you have every right to say, "No, officer, I don't want to speak to you." If the officer wants to stop and frisk you, again, don't stop them. Let he or she do whatever they're going to do. If they find something, again, don't say anything, even if the officer says that it's going to help you, because it's not. If anything, what you're basically doing is making an admission that you are the possible owner of this, which is going to make it that much harder for your criminal defense lawyer to fight your case. On the other side of it, if they find nothing, but they keep asking you questions, well, ultimately, you could run the risk of creating another situation. So what I like to say is, if the officer's asking you questions, but they don't find any contraband, but you begin giving information as to where you've been or where you're going, again, it could possibly lead to a situation where you could be arrested for something else. Now, in the case of just walking down the street, it's highly unlikely, okay, that if they find anything, if they don't find anything, simply saying where you're going to go, or where you've been is going to lead to anything. But in the example of, say, a stop, a vehicle stop, well, if you told them, "Hey, officer, I just came from the bar," or "I came from a party, I had a few drinks," well, that statement in and of itself could lead to possibly a field sobriety test, or the officer questioning from the officer regarding whether or not you consumed alcohol or illegal drugs. So the easy answer is, don't speak to police. Just give them your basic information and let them do whatever they want to do as far as a search, but never give consent. Just simply answer their questions as far as your name, provide your identification, and that's it. Okay, the next question deals with consent. I kind of touched on it here. So how will consenting to a search affect your constitutional rights? Well, you have to understand that when you consent to a search, it negates your rights under the federal and state constitution. Now, that doesn't mean that your case is over, but it seriously jeopardizes your case. So if you're stopped and police asked for consent to search your vehicle, by giving consent, you're really running the risk of making your attorney's job that much harder if they find anything. I've had cases where people have allegedly given consent, and we were able to show that the consent wasn't voluntary. But those are battles that we prefer not to handle. Now, in the situation of consent, you have to understand that consent made under duress or coercion isn't legal consent, and that's an issue that your attorney should really look at. When we're dealing with the issue of consent and duress or coercion, basically what we're looking at is a totality of the circumstances. So what would lead the judge to believe that you were somehow coerced or you did not voluntarily consent to the search? You have to understand that these issues like consent and probable cause to stop, probable cause to search, reasonable suspicion, all these issues are dealt with in a motion to suppress, where the judge, not a jury, is the ultimate fact finder and judges of the law in this case. So in the example of consent, you have to understand that with regards to that issue, the judge will look at what they call the totality of the circumstances. So all the issues involved, where were you, how many officers were present, even your level of education, what was even something as simple as what was the temperature like? Was it cold? Were you shivering out in the cold? Who was asking you questions? What was the tone of voice? How close were the officers to you? How long was the detention? Was it 10 minutes? Was it an hour and a half standing out in the cold, for instance? Again, all these are relevant for a court to determine whether or not the consent was voluntary. I had a case once where a person had allegedly given consent, and it was pouring rain in like November, and the court found that those circumstances combined with several other issues as far as the officer's tone of voice, my client's response to that tone of voice, and just other circumstances involved, that the consent was not voluntary. So you really have to, just because you give consent doesn't mean that your case is over. But again, you have to focus in on that issue with your lawyer. Okay. So final question, how does a person assert their right against illegal search and seizure or an illegal stop, something like that? Motion to suppress. Motion to suppress is the tool that your criminal defense lawyer has to use in these situations. You have to understand that issues like illegal stop, search, and seizure are all dealt with pre-trial, not at trial. If you go to trial and you haven't dealt with these issues, you've waived them. So all the issues with regards to your constitutional protections regarding search and seizure are all pretrial issues. If your intent is to go to trial, especially on any case involving a DUI, a DWI in New Jersey, an illegal gun, narcotics, or other controlled substances, I always advise clients to consider that we have to consider pretrial motions. Really, if you're going to go to trial, you lose nothing by arguing a pretrial motion, and really, if anything, you can only gain the benefit of possibly getting charges either dismissed entirely or downgraded. So again, the issue this week, I tried to draw in the safe injection site with the stop and search issue, which I think is important to a lot of people. Illegal search and seizure is always a major issue. People don't realize that, people often think of things like search warrants and come to your house in the middle of the night or early morning and search in your house. Again, typically a lot of the issues that we deal with, police don't have a warrant. And I've stated this in previous blogs and podcasts, all of which are available on GamboneLaw.com, that a search done without a warrant is presumed to be illegal. But that doesn't mean that it is necessarily illegal. But the burden is on the Commonwealth to show that the search was legal under the Constitution because of some exception. House search, I didn't discuss that this week, but I have discussed it before, is different than a vehicle or pedestrian search. I've written a lot of articles. I've written a lot of articles on that issue as well, which I encourage you to read on the website. Again, if you have more questions or questions that you want to submit to me, simply email me at alfonso@gambonelaw.com. You can also go to the website and just fill out the form there and submit a question that way. For more information, obviously, you can also call our law firm at 215-755-9000. I will see you next week, and have a great one.